It's great to be back with you. All of you have been in steady hands with Carrie the last couple of programs, and I'm glad to close out July with you. It is warm and increasingly so all across the state. Very much feels like we are in the thick of summer. We are still working through the implications of the One Big Beautiful Bill Act, the Reconciliation Bill, and as we have done over the last couple of programs and will continue today, we will have some deep dive coverage of the act and its implications. We are going to, in particular, dive into that through a look at artificial intelligence and the way in which that was and then wasn't really tied into the act's language. More on that in a moment. If Kathy, you get to the next slide, please, I can walk the audience through the agenda. Thank you so much. So I was mentioning that we'll have coverage of AI. Mark Rowick, who's been on the program a number of times over out of our Buffalo office, is back. Mark actually recently published, along with Jessica Copeland, who has presented a number of times previously, also resident in our Buffalo office. They published a piece in the New York Law Journal on what the One Big Beautiful Bill Act's implications were for AI. And we're going to get some highlights of that for all of you in this presentation that's about to follow my remarks here. So looking forward to hearing what Mark has in store. Thereafter, we'll shift to Roger Bearden, who was on last week to cover the health and human services implications of the Act. Today, the content's a little bit distinct. We're looking more narrowly at New York State and emergency preparedness regulations that affect agencies with touch points concerning OPWDD, the Office of People with Developmental Disabilities. That we recognize is a large swath of this audience, and so we wanted to make sure you were all apprised. And then we're going to shift from Roger in Albany to Jeremy Scher, who's out of our Rochester office. And Jeremy is going to be representing our litigation team. We've provided dispatches from the litigation team a couple times already this summer, and we're continuing with periodic presentations throughout this season into the fall. So I want to make sure that you get a chance to hear from Jeremy about restrictive covenants. That's coming up in just a moment. So for now, though, let me introduce Mark after I give you just some quick context points concerning the advocacy underway. We've talked about the One Big Beautiful Bill Act and the implications for the managed care organization tax. I'm confident Roger, got into that a bit last week. Certainly I have on previous programs. We saw that the Federal Department of Health and Human Services in a memorandum earlier this year had essentially said the maneuver was not something, as it were, that it was going to be supporting on a going forward basis. There was a doubling down of sorts in the One Big Beautiful Bill Act, where now formally as part of the statute, there is language also calling for the wind down. One of the key issues, though, is just how quickly that happens. New York State, of course, has a current budget that we're operating under that is heavily leveraging, as it were, of those funds on the assumption that they would be available. And under the language of the federal act, there's essentially a 3-year window by which the monies may be wound down. And there's a lot of activity right now, as you might imagine, to see that be as long as possible, such that there's a glide path for New York State to reconfigure its budget using new parameters. More on that as we learn more. Right now, there isn't anything scheduled with regard to the legislature coming back into session, which may or may not happen after Labor Day. That's an open question we're tracking closely for you. Presently, it's more likely that it's a no, and that much of the changes to the budget, if anything, will be handled through the existing authority of the executive branch under the budget director. But again, we'll see. More to come there. So just keep tabs on that with us. We'll be back with more detail as we get it. And in the interim, let's shift gears and introduce Mark. So Mark, as I've mentioned, is with us from our Buffalo office. He's someone I've had the pleasure of working with on a variety of matters involving health and health insurance, and he's also presented on this program a number of times over. And he has an interest and depth of knowledge concerning artificial intelligence that, as I mentioned, he has exercised and recently working with Jessica Copeland, who leads our cybersecurity and data privacy practice, and is also in our leadership of our AI team. They've written about these issues as they relate to the One Big Beautiful Bill Act, and we wanted to give Mark a chance to catch you all up. So Mark, the floor is yours. We really thank you for taking this time, and please come on camera. We look forward to learning from you.
All right. Well, thank you, Gabe, and welcome to all the participants out there. As Gabe mentioned, I'm an attorney, senior counsel in the business office, or sorry, in the business group out of our Buffalo office. I've been here for about 2 years. Before I came to Bond, I spent about 10 years in the health insurance, banking, financial services industry. So my practice focuses a little bit on those industries, but also, transactions and not-for-profit work, things like that. So I'm here to talk about 2 things. One is the implications of the One Big Beautiful Bill Act on artificial intelligence. And then the second one is the considerations involving an executive order that was issued just about a week ago by the White House that will have some impact on artificial intelligence in the federal government and in industries that are regulated by it. So with respect to the One Big Beautiful Bill Act, as Gabe mentioned, sort of the title here is the implications or not. And this particular issue was one that kind of was all over the map as the bill was being negotiated. So the House version originally passed in May, and it was a very close vote, 215 to 214. That version of the bill was somewhere over 1,000 pages long. I think it's maybe 1,015. And there were 5 pages in there that talked about AI, but in my view, they were pretty significant because what that House version would have done was create a 10-year moratorium on state and local regulation of AI in a lot of industries. The original version said that state and local laws which seek to limit, restrict, or regulate AI in interstate commerce, we're not going to be enforceable. And at the time, and this is still true right now, there was no federal scheme policy in place to regulate the development, use, deployment of AI tools. So it potentially left this really big gap of this unregulated landscape, and I think there's some views that that's the right approach, and other views thought maybe that's a little bit too risky. So the bill passes by 1 vote in the House, and I don't recall exactly what time, but I seem to recall, you'd see these things on the news about people falling asleep in Congress because they were there till 3 a.m, and so very quickly after the bill passed, people started picking up on this moratorium. And some of the people who voted for the bill turned around and said, I didn't know that was in there. I wouldn't have voted for it if I had known that. So the bill goes to the Senate. And again, a lot of negotiations. The Senate version passes 51 to 50 with a tiebreaker. But that AI moratorium was removed by a 99 to 1 vote. So there was almost unanimity in the Senate that, having this 10-year moratorium on state and local regulation was maybe not the best policy. As Gabe mentioned, Jessica and I had written an article that was published recently in the New York Law Journal. And, it talked about some of the implications of, the potential federal preemption. And in industries like healthcare, financial services, the impact on employment processes, there were some pretty significant existing and proposed laws and regulations that may have been preempted. Just for sort of a high level overview, in the insurance world, Several states have laws and regulations that address how AI models can be used when you're underwriting or pricing insurance products. In the healthcare industry, there are laws, regulations, and proposed laws out there at the state level involving things like, whether denials can be made through an AI tool, or whether a human needs to make that decision. There are also a lot of laws and regulations that exist, and I think we'll see some more coming around just disclosure related to the use of AI. So, whether it's a customer service or consumer facing tool, or in an industry like financial services or healthcare that tends to be more heavily regulated, you may start to see some more disclosure obligations where people are told, you're interacting with either a bot or a tool that is, AI based or is generating content. So, in theory, all of those, state and local laws and regulations could have been preempted. For now, they're not. But last week on the 23rd, there was an executive order issued that applies to federal procurement, at least to start. The title of it is Preventing Woke AI in the Federal Government. And what's interesting to me about this order is, if you read it, it's not really all that different from a lot of the stuff that you see happening already at the state level. It may apply, with a slightly different scope. But what the order is about is ensuring that LLMs, large language models that are procured and deployed in the federal government are accurate, do not create, biased output. And that is, largely consistent with, I think, the principles you see at the state level. And, in my opinion, I think that's consistent with what any business would be interested in if a business were using or relying on these models. You want to make sure you understand how it works. You want to make sure the outputs are accurate. You want to make sure it's not building on mistakes or repeating mistakes that can have unintended outcomes. So the executive order, it directs the OMB to report back sort of toward the end, 120 days, which is November 20th, and to provide guidance on implementation of an AI procurement policy for federal agencies. And it has, I think some potential, significant considerations that folks in regulated industries would want to be aware of. So one of the things that it contemplates is a policy for due diligence and disclosure when these models are being procured. And again, that is very similar to what you see in a lot of existing state laws, regulations, policies. The general notion, you can't just rely on the supplier to tell you, that their product works. You may need to actually, do your diligence, get, specific disclosures, really understand what it is that's being purchased and deployed. And that involves, potentially it involves some considerations around confidentiality and trade secrets, but I would imagine there will be a process to protect those. One of the other things that's relevant, and this may flow down to, businesses that do business under federal contracts, is a requirement that, specific contract terms be included when AI tools and LLMs are being procured. One that to me is significant and a potential challenge is there is a notion that if an LLM is procured and implemented and deployed, and then it violates these principles around accuracy and being ideologically neutral, that the contract would require, the licensor or developer to actually pay the cost to decommission it. And, if you've worked with these kinds of systems, they can be very complex and very expensive to actually stand up and implement. So, I think there's some potential consideration there when it comes to negotiation of the contracts. The executive order also contemplates amending existing contracts, which I think would be a real challenge because, at least in my experience, you negotiate a contract, you negotiate the risk, you negotiate your price. And then if you go back to your supplier and say, we want you to take on more risk and responsibility and we don't want to pay any more money, they tend not to be very receptive to that. So, for now, I guess this executive order potentially could fill some of that void at the federal level in terms of having, a federal AI policy that applies at least to, some industries that are doing business with the federal government. But we'll have some more information toward the end of November when those OMB reports are delivered.
That's really helpful, Mark. Thank you for the updates. And we'll continue to track these issues both within the reconciliation bill to whatever degree there are emanations, and it sounds like all the more so via the executive order language, more to come. And so let's shift now to our next speaker, who's Roger Bearden from Albany. And Roger is here not to talk about the reconciliation bill this week, but is back again because there's still plenty else happening. And we're going to learn about emergency preparedness regulations. Roger, please go right ahead, and thank you for coming back.
Well, thanks for having me, Gabe. And I think this returns to the origin story of this webinar, which is responsiveness to regulations that were being issued and executive orders with respect to the COVID-19 public health emergency. So I wanted to kind of give a framework here, which is that the general framework in New York State tends to be that emergency management occurs at the county level. And I say that as a general framework because there are requirements on each county to have plans in place. And, typically, no matter what type of business or regulated space you might be in, you would be interacting with that county level plan so that your activities integrate within that. There are, prior to these regulations, a number of sector-specific requirements. Nursing facilities have had, for many years as a product of federal law, requirements regarding emergency preparedness. Public schools have requirements. Public sector employers, both of those two are derivative of state legal requirements. So in all these instances, businesses would have plans in place that would hopefully sync up with these larger regulatory and statutory structures around emergency preparedness. So now there's a new set, if you happen to be in the developmental disabilities space. The origins of these new regulations lie with an Office of State Comptroller report, which examined the performance of OPWDD over a period of time during the COVID public health emergency, and alleged deficiencies around emergency preparedness specific to facility-based care in the OPWD world. So this would be group homes and day facilities, day rehabilitation facilities that are holding operating certificates from OPWDD. And so these new regulations require any regulated entities that operate such facilities to develop both a plan that is an agency-wide plan and then a specific plan for each facility. And those plans are supposed to derive from what's typically called an all hazards approach, which you'll see that language more or less in most other types of regulations around which is essentially a risk stratification approach where the facility and then the operator of those facilities would do a reasoned analysis of the types of risks that are out there, that and how what kind of mitigation strategies are appropriate to address those risks. One of the challenges that I think folks are seeing with those regulations and a compliance issue that folks are trying to really wrap their heads around is how to sync up those kinds of facility specific plans with the larger county emergency management issue. This has been an issue for a long time with respect to nursing facilities, also intermediate care facilities, which are licensed by OPWDD in New York, but are regulatorily nursing homes. You've seen examples in, for example, the Superstorm Sandy in New York City, where everybody had their specific plan, but those plans were not coordinated with the tragic consequence of folks not necessarily being able to evacuate because it was all dependent upon the same transportation infrastructure. So that's something that I think will need to be worked out as folks begin to develop those plans. OPWDD is going to be oversighting that through their quality improvement division. So this will be another review that folks will undergo as they go through their licensing reviews. But it's also, whether you operate in the OPWD space or other spaces, it's probably a good time to take a look at what your organization has in place with respect to emergency preparedness. And obviously, if you have specific facilities or operations that fall within more discrete regulatory requirements, to review those as well.
Roger, thank you. I wholeheartedly agree. And I'll note that, as a team, we have competencies and experience in helping to build those plans and pressure test them, including in my previous work before I got to bonds. So what I was just going to say, excuse me, is to encourage all of you, please, to reach out if you are seeking assistance in that space. We are happy to try to give you a hand. Let's though shift to our final speaker for the afternoon, and that is Jeremy Scher. Jeremy is with us from Rochester. You've seen Jeremy on this program before, although not for a little while, and Jeremy was sharing he's glad to be back, and you're representing the litigation team talking about restrictive covenants today. There's a lot to think about within that parameter, and we're going to learn from Jeremy exactly why it matters. And Jeremy, the floor is yours. Thank you very much in advance.
Thanks very much, Gabe. So I've been litigating over restrictive covenants for pretty much all of my roughly 20-year career, starting with getting urgent assignments as a junior associate to draft a application for a temporary restraining order to prevent exposure of trade secrets, and it's still something that occasionally causes me to rush off to court. And it's now something that, however, I can handle with a lot less stress because the law really has not changed very much in the last 20 years regarding non-competes, non-solicits, and other kinds of restrictive covenants. Despite the fact that both the federal and New York State governments have attempted to rein in restrictive covenants without success. So the first slide goes through some of the basics of restrictive covenants. By restrictive covenant, like I said, I mean agreements that either say that an employee will not compete with the employer in a new job or otherwise. Also, there are non-solicits, which can bar, which are basically specific forms of non-competes, which say that an employee can join a competitor but cannot try to solicit former clients of the former, clients of the former employer or employees of the former employer. And then there's the much more general non-disclosure or confidentiality agreement, which is technically a restrictive covenant, but it's generally easier to enforce if you have sensitive information in your business. I just note in this slide that it's always a good idea to recite the language of the of a certain exception found in the Defend Trade Secrets Act because it is a nice option to have the ability to bring a federal Defend Trade Secrets Act claim against an employee who takes trade secrets. And if you do so and you include that disclaimer language or notice language, then you are allowed to seek additional penalties and recovery from the former employee. My first note on this page is that it's still courts, not the legislature, that has the final say on what types of restrictive covenants are and are not enforceable. That requires businesses to talk with lawyers and understand the somewhat confusing history of the last 25 plus years of court decisions on restrictive covenants. On the next page, there are some basics for trying to draft an enforceable restrictive covenant. And one issue here that's less self-explanatory and very important is what I note as the employee choice doctrine. So there are all kinds of considerations for what makes a restrictive covenant reasonable, but there's a specific kind that is generally considered reasonable in all cases, which is if you give an employee a certain benefit in exchange for not competing or not soliciting after they leave your company. For example, stock options or any kind of post-employment benefit. If you give an employee a post-employment benefit in exchange for not competing or not soliciting, courts typically will enforce your restrictive covenant to the extent that the court will force the employee to return whatever post-employment benefit they received. The last note here is also a major exception, which is that if you sell your business to a buyer and you include there's included in the sale, or you purchase a business and there's included in the purchase agreement a requirement that the seller not compete with the buyer, that is almost always enforced. That's a special situation, and I will not be talking about it very much. Virtually everything else I say in this presentation will be about employee restrictive covenants. Again, sales of businesses are treated differently. On the next page, we talk about the sort of general permissible grounds for restricting competition, all of which stem from a 1999 Court of Appeals or New York High Court decision called BDO Seidman versus Hirschberg, which is still 26 years later the final say on permissible and impermissible restrictive covenants. It's a very long, convoluted decision, and courts and lawyers and businesses have been trying to figure out what it says for all this time. But now courts have essentially focused on a generally agreed meaning of it, which makes it easier to explain. For a non-compete, what I have to say about that is non-competes are very difficult to enforce. There are many types of businesses that simply cannot restrict competition because many businesses, no matter how successful they are, cannot identify what's called a legitimate interest to be protected. Legitimate interests under BDO Seidman are very few in number. True trade secrets, not just proprietary information, but trade secrets, which is another topic for discussion. In other words, something that is carefully guarded, truly held secret, and is provides an advantage that competitors would benefit from if they knew it. Real trade secrets, they can be protected by a non-compete. So higher level officers or executives of companies that have trade secret information, such as a highly confidential formula or marketing plan, they may be subject to an enforceable non-compete. There's the term unique or extraordinary employee. That's almost never found in the real world. That applies to celebrities and other people that are truly one of a kind for the most part. And then there's the third topic, which is goodwill. This is also somewhat misleading because goodwill, to be protectable, has to be solely cultivated by the employer. And I see many cases where employers try to bar competition or solicitation from sales representatives or other people who are customer facing, who have essentially on their own through their own efforts developed goodwill for the employer. And in many cases that cannot be restrained. Goodwill has to permissibly stop competition or solicitation for the employer's goodwill. You have to have a very carefully written non-solicitation clause, and that requires legal consultation because it is not something that can be picked up online or just known from common sense. There's very specific language that must be used to ensure that the bar on going after a former employer's goodwill is enforceable. On the next page, there's this concept further from BDO Simon that non-competes and non-solicits cannot be harmful to the general public or unreasonably burdensome to the employee. Courts increasingly realize that there are negative societal effects from restrictive covenants, particularly in professions where the public needs some degree of competition. So, for example, I had a case once with an anesthesiologist who was sought to be who their employer sought to restrain, and the court found that there was a public benefit to this anesthesiologist not being put out of business because their services were needed in their region. On the next page, you'll notice I'm going through this fairly quickly. It's easy to get bogged down in these details. I'm just trying to give the general, the big picture. If you do not have a restrictive covenant that's enforceable as it's written, and I have to say that most restrictive covenants that I encounter that someone else drafted years or decades ago are not enforceable as they're written, then BDO Seidman makes things very difficult for the employer. The employer has to prove just to get the covenant partially enforced, in other words, rewritten to have a narrower focus as opposed to eliminated completely. The employer has to prove essentially that it has some degree of a legitimate purpose behind the covenant, and it's phrased in this long paragraph that I won't read from BDO Simon, but you can see that again, it puts the onus on the employer to prove its legitimate motives for restraining the employee, and a desire just to reduce competition or prevent other employers from getting access to trained and experienced employees is not good enough. Because this is a discretionary standard, and again, it only allows at best a narrowed application of an overbroad covenant, courts are increasingly unlikely to allow even the narrowed application to go forward because BDO Seidman, the same case that set this standard, has been on the books for over 25 years. And the idea is lawyers and their clients have had plenty of time to understand what BDO Seidman means, as convoluted as it is. On the next page, I have to emphasize that if you proceed with an overbroad and unenforceable restrictive covenant, it is very likely that a court will refuse to enforce it or strike it down. And if you go into court to seek, if you're an employer and you go into court to seek a preliminary injunction to essentially put a employee who is in breach out of business, the judge will likely telegraph that you have an unenforceable restrictive covenant by denying your preliminary injunction. And that decision is usually the end of the case because employers don't want to go forward with a with litigation and face the prospect of potentially getting their standard non-compete or non-solicit invalidated. I have a little more on some court decisions, a recent court decision from the High Court called Brown and Brown, but I won't go into that in detail. It basically just emphasizes everything I said, that for at least the last 10 years, New York courts have been not receptive to restrictive covenants, and it's hard to find loopholes, such as in Brown and Brown, the employer tried to use Florida law to enforce the covenant more broadly, and the Court of Appeals refused to allow that. And then I just want to skip ahead to the last slide, which you may have heard that the FTC under President Biden tried to ban non-competes, and the New York State Legislature has repeatedly tried to ban non-competes. None of that has actually stuck in the law. The FTC rule that would ban non-competes is held up in litigation, and President Trump's FTC reorganized FTC is unlikely to want to push it forward. And Governor Hochul has repeatedly held up passage of legislation to ban non-competes, and there is no progress publicly uh, to be seen, online or otherwise known to the public about getting any of these anti-non-compete bills passed. So in the end, the courts remain the final say on these issues, and we welcome the opportunity to consult with you and your colleagues about drafting and enforcing permissible restrictive covenants.
Jeremy, thank you. It's very clear that this is textured and it's important to get it right so that you don't cross lines, however unintentionally. So we're glad that you could walk through this material. As Jeremy alluded, it was coming at you, the audience, fairly quickly. All these slides will be available shortly after the webinar, so you can click back through on your own time. And if you have questions of any sort around restrictive covenants, please reach out to Jeremy. Kathy, if you would advance the next slide, please, the one thereafter, I'd appreciate that. Here's where you can reach the various presenters today. If you have any questions at all, just email us, call us. We're here to help you. I will be back with you as your host next week. Carrie and I did a little bit of juggling over these last couple of weeks, and then so I will host. Thereafter, we'll be alternating again. I look very much forward to seeing you as we cross into August. We're always interested in your recommendations for topics and content, so reach out to me in that regard as well. And I look forward to seeing you in a week. Have a wonderful afternoon in the interim.